So if you have questions, we'll try to monitor and answer it as they go. But if not, maybe we'll do it at the end. My name is Elizabeth. I'm a staff attorney here at the Family Center. My name is Holly. I'm a legal intern here at the Family Center. And we are so excited to be going through this presentation with you. As you can see clearly, end of life financial planning. So it is it's a tough topic to talk about. We definitely understand that. So I want to preface it with really take your time, be gentle with yourself, and know that you are really doing the best thing by educating yourself and planning for your future today. Let's see if we're able, there we go. So as mentioned before, we are part of the Family Center. We are one branch of several. So there's, oh, can you hear us? Okay, great. So there's other branches here, family services, mental and behavioral health, but our team specifically focuses on civil legal services for anybody in the 5 boroughs with a serious life-limiting illness or disability. Because we believe that you shouldn't have to deal with all these legal troubles when you've already got enough going on medically. And so these areas of practice are housing law. So we've dealt with eviction issues, non-paying issues. There's public benefits and healthcare access. So SSD, SSI, family matrimonial law. This is everything from 17A guardianships of an adult to sometimes divorces. And then the category that we're discussing today is lifetime planning and small estate planning, specifically end of life financial planning. And so as said before, this is free civil legal services for anybody in the categories that qualifies. And at this time, we're not offering the sliding scale rates for people with moderate incomes, just because we have a limited staff at this time. And of course, as a law student and a staff attorney, we have to have the disclaimers for you. And we want to make sure you know that this is an educational overview. These are really complex topics with plenty of rules, processes, requirements that we're simply just not going to be able to get into the weeds of today. But we want you to be able to make educated decisions going forward. So again, this is not legal advice. We're not forming an attorney-client relationship today. There's a whole lot more paperwork that goes into that. But we can give you a broad overview. So nothing specific to your situation, unfortunately. We really recommend for your individual counseling that you consult with an attorney about your end-of-life planning. Now, we've been tossing around this term, and again, I know that it's a heavy one. So end-of-life financial planning. It's the process of preparing for your future and making sure that everything is in order, your belongings, your finances, for when the day comes that you pass away and somebody else is going to be taking care of those assets. Now, again, I really want to stress again, be gentle with girls, because this is a stressful process, but eventually it will ease the stress, it will ease the burden and make your life easier, have peace of mind, and make it easier for those that you love. And it's a multi-step process, and really the groundwork is making sure that you get your documents together and keep them in a safe place. So anything with your banking, your assets, you want to be keeping that probably in a safe if you have access, or at the very least a filing cabinet somewhere where you can just stay organized and on top of these documents. Oh, and once again, if you have any questions as we go, please put them in the chat. We'll be checking it regularly and try to give you answers as we go along. Awesome. Hi, everyone. So we'll go over advanced directives generally first. An advanced directive is a legal document where you can express your wishes in the event that at some other time you're unable to make decisions on your own. And so I'll go over some non-financial advanced directives first, because the focus of this presentation is financial lifetime planning, but just knowing that there are other types of advanced directives. A living will and a healthcare proxy. This allows you, a living will allows you to communicate your wishes regarding medical treatments and healthcare decisions, and also including life-sustaining treatments. So sometimes people have specific wishes due to religious or personal reasons, and so the living will allows you to put that in writing. And so related, a healthcare proxy is a document that allows you to name somebody that's going to be your agent, to make medical decisions for you if you're unable to do so. So the healthcare proxy allows you to name an agent, and then the living will is sort of an extra form that if you do have these specific wishes, it's in writing. A designation of person and parental relation or a designation of standby guardianship allows you to name a temporary guardian for your minor children in the event if you become incapacitated or pass away. And additionally, an appointment of agent to control disposition of remains. This allows you to name a person that you would like to control the disposition of your remains in like burial or cremation after your death. And that allows you to specify what your wishes are. So today we're going to be presenting on financial advance directives, but you can, of course, feel free to contact us for the other types of advance directives that I mentioned. And so with that, I'm going to go and we're going to discuss a power of attorney. So a power of attorney is a legal document where you, as the principal, you can designate another person, often referred to as an agent, to act on your behalf and make decisions about your legal and your financial affairs. And so there's two types of powers of attorney, which is important when you think about when is this authorization going to go into effect. So a spring power of attorney is when you specify exactly when your agent's authority will take place. Such as, if you lose capacity or if you turn a certain age, stuff like that. A durable power of attorney remains in effect even if you later lose mental capacity. So if somebody's diagnosed with like a neurodegenerative disease, of course, when you're signing it, you have capacity, but over time, maybe your capacity sort of goes down or it fluctuates. So at a certain time, then it will still remain in effect even after somebody does lose capacity. So this, could potentially prevent family or friends having to petition for guardianship to manage your affairs. And in cases like that, we're thinking about Article 81 guardianship, which of course can be time consuming and stressful for a family or a friend to have to do this. It's notable that a power of attorney is only valid while you're alive. It's not effective after somebody passes away. And power of attorneys can be modified and personalized to meet your needs and wishes. It has to be signed. It needs 2 witnesses. It needs to be notarized. There has to be specific wording and information in this document. Who to name as your agent. So we need somebody that's over 18, an adult, somebody that you trust completely, of course, because this person could, have access to your bank accounts, access to your assets, etc. Somebody who's responsible, organized, and competent.
Hi.
You can appoint more than one agent at the same time, and you can require that they have to either act together, or you can specify that they can act separately. The power of attorney authorizes your agent to conduct financial and legal transactions on your behalf, and it gives them access to your accounts. So this is a pretty big authorization to be giving somebody. So it's extremely important, that you pick somebody that's reliable and somebody that's trustworthy as your agent. And we recommend to consult with the lawyer before completing a power of attorney. So that's power of attorney. We're going to move on to estate planning generally. Estate planning refers to the process of preparing for the distribution of your money and your property after death. And what your estate refers to is everything that you own or that is owed to you at the time of your death. So we're thinking money, personal belongings, investments, real estate. So we're thinking of both physical property and then intangible assets as well. And regardless of whether one is rich or poor, estate planning allows you and not the state to decide, what happens to your stuff. And we can discuss in a little bit, what that means about having the state decide or passing, without a will, stuff like that. Estate planning can be done in a number of ways. It can be, executing a valid last will and testament, or sometimes more referred to as a will, or creating certain types of trusts, and in other ways as well that we'll go over. It's important to discuss and to consult with an attorney about estate planning. We'll go over a little bit more about, executing a valid will and just sort of those requirements behind it. Again, we're thinking about witnesses, something being notarized, etc. For people with large estates, so a lot of money or property, estate planning can minimize the amount of estate taxes that are owed. So we're going to start off going over the last will and testament, or a will. And this is not to be confused with the living will that I discussed earlier that sort of goes with the healthcare proxy. I think sometimes people get those confused, understandably. So the last will and testament, called a will, this is a legal document that directs how you would like your personal affairs, both financial and non-financial, and your assets handled after your passing. Without a will, the courts and the laws of your state will determine what happens to your assets or minor children. Not everyone needs a will, but it's important to think about for all adults. A will must meet very specific requirements in order to be legally valid and enforceable. So that's why we strongly advise getting assistance from an attorney and not downloading something from the internet. I know there's like a lot of resources out there, but because we want to make sure that later down the road, somebody is arguing that a will is not valid and therefore not enforceable. So it's best to just go through the proper channels. Many assets that have a beneficiary already, so say a bank account or a life insurance policy or a retirement account, will often go to the beneficiary that's named. And so it's not going to be distributed according to the will. And we'll definitely go over this more in the following slides. So in your will, you name somebody that is called the executor. And what the executor does is that they are to carry out your wishes that you write and that you express in your will. And this person is in charge of finding and totaling all of your assets and property and all of your debts. And so of course, your executor is somebody that you trust, somebody that's going to respect your wishes, and somebody that's, just organized and again, somebody that you trust with your last wishes. The executor will work with the surrogates court. So that's, the court that handles estates. Sometimes it's referred to as probate court, but in New York, we refer to it as surrogates court. And so what the surrogates court does is they have to approve the will and oversee the executor's work. And what this process is called is probate. And the probate process makes the will a public document. So the costs of the probate process are based on the size of your estate and are generally paid using assets from your estate. If you owe any debts when you pass, your creditors must be notified of the probate process. And they may file claims to get paid out of your estate before they pass along to your loved ones. So a will can do many things, not just addressing financial assets, but you can also include directions for who will get your property. So this can include giving away specific items to people or giving away certain amounts to specific people. You can name a guardian to care for your minor child. And your will can also require the creation of trusts for minors, people with special needs, or other beneficiaries. You can include instructions about burial or funeral arrangements. though, because this isn't going to be read immediately, and if depending on somebody's wishes, cremation or burial, that happens, of course, immediately versus the will is going to be read maybe weeks or months later. So, we do advise discussing your wishes with your family and friends in advance. But then also, like I mentioned before, there is the document appointment of agent to control disposition of remains, if you haven't already made arrangements. So when would somebody need a will? Typically, this is good, if you have very specific wishes for specific items or amounts of money to go to a very specific person. If there's somebody that you would like to inherit from you via intestacy laws, and that you maybe don't want to leave anything to, you can specify that in your will, and what that is referred to as disinheriting someone. And we'll go over in more depth about intestacy laws and what it means to pass, again, when we're saying, what the state decides. If you want to leave anything to non-family members, so non-relatives do not have the right of inheritance without a will. Again, we're thinking about intestacy, unless they're already a named beneficiary on an account or jointly own some types of property with you. If you want to leave anything to family members who would not inherit under intestacy laws, so we're thinking people that are further removed, not your immediate family members. And if you have a large and or complex estate, sometimes tax considerations can apply. So those are the points on why somebody might need or want a will. Real quick, let's check the chat, see if anybody has questions. Accept. Oh, great. Alrighty. Awesome. And so passing without a will is referred to as intestacy. And so a person who dies without a valid will is said to be intestate. And intestacy laws spell out who will receive your property. And only family and relatives are entitled to get property under intestacy laws. Assets will not pass to a friend or to charities. In New York, if you have a spouse and no children, the spouse inherits everything. If you have children but no spouse, your children will inherit everything. If you do not want to have a spouse or a child, if you do not have a spouse or a child, then your parents will inherit everything. If you do not have a spouse, child, or parents, then your siblings will get everything unless you have grandchildren, in which case the grandchildren would, and so on. So intestacy laws, that goes over sort of the order in which somebody can be entitled to what's in your estate. In New York, your property will never revert to the state. If family members cannot be located after your death, the public administrator will hold the property indefinitely. So bequests to minors, or sort of gifts or inheritance to minors, we advise that one thinks carefully about how to plan for any minor children who are under 18, who may receive part of your estate. So if money is left directly to a child, a guardian of the property needs to be appointed by the surrogate's court to manage the property that the child has inherited. The guardian of the property will need to obtain the court's permission before spending money on the child's behalf, even once guardianship is granted. There are benefits to this system. It helps ensure that the property that you've left for a child is kept safe until they turn 18, and helps protect it from being wasted. There are, of course, also drawbacks because it could make it difficult for the child's caregiver to access funds that the child may benefit from before they turn 18. It also can take a lot of time and sometimes money to navigate. Of course, just dealing with the courts, especially in New York, where there's a lot of people, things often take a lot longer than they do elsewhere. And so the property is turned over to the child once they turn 18, which might be too soon for some young adults. So there are two important alternatives to know about: UTMA accounts and trusts, which we'll go over in the next slides. So UTMA accounts, which is short for Uniform Transfers to Minors Act, which is a New York law that authorizes a special kind of bank account that a custodian manages on behalf of the minor child. This account will be titled the custodian's name as custodian for, and then the minor's name under the New York Uniform Transfers to Minors Act. Any adult can act as the custodian of the account, and the custodian must utilize any funds for the benefit of the minor, and they must keep the UTMA funds separate from their own money. They can also save money for the child in this account. Some benefits when we're thinking about, UTMA accounts versus bequests to minors. We're thinking, that the custodian wouldn't need court approval to use the money. And there's little to no oversight of UTMA custodians. These transfers are irrevocable, meaning that you can't take them back. And an UTMA transfer must be made during your life or in your will as part of your estate plan. The account becomes the property of the child when they turn 21, or unless you specify the age of 18 when you make the gift. If you're considering using an UTMA account, you should consult with an attorney. So some of the benefits of an UTMA account is that it's free, it's easy to set up and manage, and it gives the custodian, a lot more freedom to save or spend the money for the child as they see fit. Some of the risks or drawbacks is that, there's the risk of the money being wasted or spent unwisely, since there's no oversight of the custodian. There's no, the surrogate's court is not looking over as to what the custodian is spending it on. Again, 21 may be still too young for a child to take full responsibility of the property. And it might not be ideal for children or young adults with disabilities, because that could possibly lead to eligibility problems when the child turns 21. So we're thinking about, are they receiving what we refer to as means-tested benefits? So trusts for minors. You can have an attorney draft a trust as part of your estate plan, and the trust is a legal relationship where one person or an entity and a trustee or the trustee has legal title to the property that they manage for the benefit of the other person, so the beneficiary. So we have two parties: the trustee, the person who has legal title to the property, and the benefit, so the beneficiary. Creating a trust for a minor can be another way to avoid guardianship of the property. Again, we're thinking about surrogate's court and just sort of the administrative burdens that is behind filing in court. Trusts can be, but don't have to, be created in wills. There are many other different types of trusts. And a trust can be helpful if you have specific wishes or concerns about how your bequests or your gifts will be spent. Trust can be expensive, especially if you or the estate hires somebody to act as or to advise the trustee. So if you're considering creating a trust, we again advise consulting with an attorney. So bequests to people receiving public benefits. And again, sometimes these are means tested. So we have to be mindful of how bequests could possibly affect or hurt somebody's benefits that they're receiving. So it's also important to consider whether any of the beneficiaries of your estate are or may start receiving government benefits like cash assistance, SSI, or Medicaid. Many of these benefits have both income and resource limits, and a sudden inheritance could create eligibility problems for people receiving these benefits. Medicaid and SSI have some special rules that allow people with disabilities to own property and still keep their benefits. So some options for people that are on SSI and Medicaid is setting up a supplemental needs trust, referred to as an SNT, or an ABLE account to help a disabled beneficiary inherit a share of your estate while keeping their important government benefits. If any of your beneficiaries are disabled and are receiving government benefits, such as SSI, Medicaid, or cash assistance, or you think that they might be in the future, it's important that you discuss this with an attorney. And so, when we're thinking about, the effect of how inheritance can affect somebody with public benefits, the money could be helpful, but then also it's not, long-term or not a long-term solution. So sometimes, when you need Medicaid or you need SSI, that's, you don't want to make them ineligible or closing their period of eligibility as well going forward. So property passing outside of the estate, certain types of accounts and assets pass outside of the estate, meaning that when you die, they go directly to the named beneficiary, and they're not controlled by your will, and distribution is not generally overseen by surrogate's court. So some examples and common assets that pass outside of estates are payable on death accounts, life insurance policies, certain retirement accounts, and certain types of trusts. Additionally, real property that's owned jointly. How this property passes depends on who the owners are and what kind of joint ownership that the two have. So we'll start with payable on death or POD beneficiary. And this is, good to think about as an alternative to a will, or maybe in addition to a will. Essentially what you do is you designate a payable on death beneficiary, which could be helpful for your end of life financial planning. A payable on death beneficiary can be designated on any checking, saving, or credit union account. And if you designate a payable on death beneficiary on your bank accounts, the person who you name as your beneficiary won't have to go to court to gain access to these accounts. You can change your payable on death beneficiary at any time, and designated a payable on death beneficiary does not change your access to your money while you're still alive. Your beneficiary will not be able to control or use the money during your lifetime. Quick access to your bank accounts can be useful to your family and friends if money is needed to pay for costs such as burial, funeral, or other immediate needs. Again, these are things that happen closer to one's death versus having to either litigate or go through probate. That takes a longer time. So how does the process of designating a beneficiary work? To designate a payable on death beneficiary, most banks require that you go in person to your bank branch and to provide the full name and date of birth of the person or persons that you're designating as your payable on death beneficiary. Upon your death, the payable on death beneficiary will be able to access the funds as if the bank account belonged to them. So what the beneficiary would have to provide is valid identification and proof of your death. So like a death certificate. If you want to change your payable on death beneficiary, you will need to go to the bank to do this. You cannot change your payable on death beneficiary in your will. So now we're going to move on to life insurance. If you have anyone that's dependent on you financially, you might want to consider purchasing life insurance. You can choose the person or people who get your life insurance proceeds, so life insurance beneficiary, and you can also choose a backup beneficiary as well, referred to as a contingent beneficiary. There are four types of main types of life insurance policies: term life insurance, whole life insurance, universal life insurance, and variable life insurance. So here are the four main types, and term life insurance provides insurance for a specific period of time, say 10, 20, or 30 years, and you must pay a premium every month to keep this life insurance active. If you die during the term of the policy, then your beneficiaries will receive a death benefit. If you live to the end of the term of your policy, no death benefit will be given to your beneficiaries. Whole life insurance lasts for a policyholder's lifetime and not just for a term. It provides a death benefit to beneficiaries as long as the premiums were paid during your lifetime. If you stop paying while you are alive, the policy can usually be redeemed for money or its cash value. Universal life insurance provides insurance similar to whole life, but with a little bit more flexibility as to the amount of the premium, death benefit, and cash value, which can all be adjusted during the duration of the policy. And lastly, variable life insurance provides insurance that functions like either whole life or universal life, depending on the type that you choose. But the policy holder of the variable life insurance policy decides how the cash value is invested, as opposed to the insurance company. So it's important to note that whole, universal, and variable life insurance are all considered assets by Medicaid, public assistance, SSI, and other public benefits programs because they have a cash value. And so having this type of insurance policy could affect your ability to receive these types of public benefits. So again, we just advise that you consult with an expert or an attorney before purchasing this type of life insurance if you do receive or maybe anticipate receiving public benefits. So how does life insurance work? When you purchase a life insurance policy, what you'll do is that you'll designate your beneficiaries or beneficiary, usually with their full name, date of birth, and social security number. Again, you can change your beneficiaries at any time by contacting your life insurance company, and you should inform your beneficiaries so that they know to collect the life insurance proceeds when you do pass. When you die, your beneficiary should contact your life insurance company, provide proof of who they are. Again, we're thinking a government ID and proof of your death, so a death certificate. The company will then send them a check, and it's usually processed within a couple weeks, making it relatively quickly and easy for a loved one to access this money after you've died. Many people plan for their life insurance proceeds to be used to pay for their burial for this reason. So some life insurance important tips. Your will does not control your life insurance policy. So as long as you have named a beneficiary, life insurance passes outside of the estate, regardless of what your will says. You can change and update your beneficiaries at any time by contacting the insurance company. And for most New York life insurance policies, if you get divorced and you previously named your spouse as a beneficiary of your life insurance policy, the divorce will automatically revoke this designation. If you still want your ex-spouse to be the beneficiary, you will need to complete another beneficiary designation, naming them after your divorce is complete. So once there's been a final judgment of divorce. However, some life insurance policies, especially ones that you might get through an employer, are governed instead by a law called ERISA, which provides that your ex-spouse still receives your life insurance proceeds if they were previously designated as a beneficiary. So it's important to reevaluate your beneficiaries after big life changes, such as the loss or birth of a family member or divorce. So retirement plans. The types of retirement plans are an individual retirement account or an IRA, a Roth IRA, 401k, 403b, 457, a thrift savings plan, private pension, and Social Security retirement benefits. So, many different types of accounts. And so beneficiaries of these plans, for some types of retirement plans, you can name a beneficiary who will receive the funds in the plan directly upon your death without having to go to court. So if you do not name a specific beneficiary, the plan or account may have its own rules about who gets the funds after your death, or it may go to your estate. For some accounts, you may have to include your spouse as a beneficiary. So the rules do vary depending on the type of account. But we'll move on to go over Social Security survivors benefits. So when you die, your loved ones may be entitled to monetary benefits through Social Security Administration or SSA, and you must have worked long enough under the Social Security rules for your family to qualify for these benefits. So who is eligible for survivor's benefits? First, widows or widowers can receive benefits if they're 60 or older, 50 or older and disabled, or any age if caring for the decedent's child who is younger than 16 or disabled and receiving Social Security benefits. Children can also collect benefits if they're unmarried and younger than 18, between 18 and 19, but in school full-time, or 18 and older and severely disabled, if the disability started before they turned 22. Parents are also potentially entitled to survivor's benefits that are age 62 and older if they were dependent upon their deceased child for at least half of their support. Additionally, if you have been divorced, your former wife or husband, age 60 or older, or 50 to 59 if you're disabled, can get benefits if your marriage lasted at least 10 years or at any age and length of the marriage if caring for your child who is younger than 16 or disabled. A surviving spouse or child may receive a one-time special lump sum death payment of about $255 when you die, and survivors must apply for this payment within 2 years of the date of death. You can also apply for benefits by calling SSA or visiting your local Social Security office. So the lump sum death benefit from SSA or Social Security Administration. A surviving spouse or child may receive a special lump sum death payment of about $255 if they meet certain requirements. So some of the eligibility requirements are that the surviving spouse must be living in the same household with the worker or the decedent when they pass. If they were living apart, the spouse could receive the benefit if during the month the worker died, the spouse was already receiving benefits on the worker's record, or if the spouse became eligible for benefits upon the worker's death. If there's not an eligible surviving spouse, then the lump sum can be paid to the worker's child or the children if during the month the worker died, the child or the children was already receiving benefits on the worker's record or became eligible for benefits upon the worker's death. As with the other benefits, you must have worked for long enough in order for your surviving spouse or the surviving children to receive the lump sum death benefit. So there are working requirements for a certain amount of time. So another thing to consider, especially in New York, are apartment succession rights. Only certain types of rental apartments have succession rights, and what succession rights refer to is essentially the right for certain people to live with you, who live with you, to stay in the apartment after you leave or pass away. So these include rent-stabilized apartments, Section 8, Mitchell-Lama, and or NYCHA apartments. So as many of you know, these are pretty valuable in New York City. They're not considered what we refer to as market apartments. So sometimes they have stronger tenant protections and other sort of benefits that a tenant doesn't get in a market apartment. So unregulated or market apartments do not include succession rights, and rented apartments are not assets that you can pass along in a will. Whether your loved one gets to stay in the apartment or keep the voucher, so if we're thinking about Section 8, depends on the laws or regulations governing the housing or housing program rather than a state law principles. So, we're thinking about what's the agency that runs this type of program. So with Section 8, that can be run by HPD or HUD, or sometimes there's NYCHA Section 8. So those rules will apply to whoever gets to keep the voucher or is entitled to succession rights, and not a state law principles. The rules are completely different for apartments and property that is owned rather than rented.
So for many apartment programs that do include succession rights, a person can only stay in that apartment or keep the subsidy if the person has lived with you in the apartment and used it as their primary residence for several years prior to your death or leaving. There are also usually special requirements about which relatives are eligible. And of course, these vary by the program and the apartment, but we're thinking about, things that we're thinking about is, have they lived with you in the apartment as their main residence for several years? And then are they an eligible family member? So it's important to add your loved one to the lease if possible, or otherwise informing your landlord, of course in writing, that your loved one is living with you. For NYCHA Section 8, the relative may need to be added to your household composition, and you may need to get permission before they move in. Your loved one should update their bills, bank accounts, voter registration, school or work records, and state-issued IDs with your address. You may want to also consider adding their name to gas, electric, or internet bills. Again, this helps to prove and to show documentation of their residency later on. If you have concerns about what will happen to a family member living in your apartment after your death, you should always consult with an attorney.
Alrighty, so I'm going to give my colleague a minute to breathe, and I'm going to jump in on exempt resources. So we've been talking a lot about where things go and what's left behind, but we want to talk about the burial itself, the actual funeral, and everything that happens in that very tumultuous time after somebody passes away. So a lot of benefit programs like SSI have resource limits, which means that you can set up a burial fund to a certain amount that's not going to count towards the fund that you are allowed to have in your account in order to be eligible for these services. So I know for specific programs like for SSD, if you exceed, I believe it's $2,000 in your bank account, you're no longer eligible. But for things like SSI, if you have this specific amount set aside for burial funds, it doesn't count towards that limit. So you might be asking what a burial fund even is. And this is money that is specifically set aside solely for burial expenses. It can't be used for anything else because I think we all know it is wildly expensive to go through all of the burial process and everything that comes after. So this money can be in a bank account, any other financial instrument, or even what's called a prepaid burial arrangement working directly with the services. And generally, you can set aside up to $1,500 each. So if you have a spouse, then it's $3,000 total to pay for these burial expenses. And again, in most cases, as long as it is specified to this fund, it's not going to count towards your SSI limit. And just a note, if you and your spouse own life insurance policies or have other burial arrangements in addition to the $1,500 or $3,000 total for the couple, some of the money in the burial fund may count towards the resource limit of $2,000 for an individual or $3,000 for a couple. I know I'm throwing a lot of numbers around, but hopefully the slide lays it out pretty okay. And if you want to set up a burial fund, any account that you have must clearly show that the money is set aside to pay for those. You can do this by titling the account as a burial fund specifically, or by signing a statement that explicitly says how much money has been set aside for what date and whose burial. Again, it's pretty simple, but you really want to make sure that you're talking to an expert about this because it needs to be very explicit to not be contributing towards that SSI limit. And also a note is the Human Resources Administration also has its own burial exemption, but the rules there are a little different than the ones we just covered. So you're going to want to speak to an HRA worker or an attorney for more information on that. So on HRA burial assistance specifically, the burial services is its own department within HRA. So it's called OBS, a lot of acronyms thrown around. And this can actually provide financial assistance to help you meet those expenses if you are a low-income New Yorker who passes away. Because again, These are expensive services, and you really don't want to be leaving your loved ones with the burden of paying for all of these if they don't have to. So this can apply to either funeral expenses that have already been paid, or if you're planning in advance, pre-approval for the cost of the planned funeral. And what can be covered by this? It pays up to $1,700 of the cost of the funeral bill for the final dispositions. Now, final dispositions is the burial, the cremation of the ashes, anything to do with that. And in the event that the bill of the funeral itself exceeds $3,400, so this is going to be the event, this is going to be the burial plot, there's certain things that they're going to subtract from that to make sure it falls within the $3,400 cap. And that's going to be the cost of the burial plot, the grave opening, or the cremation in certain circumstances. And this is all just to keep it under the HRA's total bill, but they will cover up until that point, as long as you are an eligible New Yorker, which is any low-income New Yorker without resources or assets that are available to cover the cost of the funeral. They'll step in. Oh, and I see we have a question in the chat. Oh, I think the questions are coming. So will the presentation be available in hard copy? We defer to the host for that one. I think we might be able to. Let's see. Next up. Oh, here we go. Now, this is a big question. What happens to any remaining debt when somebody passes away? If you owe money, such as credit card bills, medical bills, all these debts might still need to be dealt with even after you pass. So there's different circumstances. If it's a debt that's held jointly with somebody else, so let's say a joint credit card account or a joint loan, then the other person, if they are still surviving, will owe the debt. So they are still responsible for it. If you leave a property with a loan attached to it, whether it's a house or a car, then to somebody it's left behind. The loan has not been paid off, then generally the person inheriting it will take over the payments in order to keep it. So it kind of tags along with that property as part of the entity itself and the value. So we say that they inherit the property subject to the mortgage of loan or loan, if you've heard that term before. And if your estate that you leave behind already has enough money to pay off the loan or the property, then you can designate some of that money to be used to pay off the mortgage or the loan, so that your beneficiaries inherit it free and clear, and that's just the property without any loans attached to it. So they are just the sole owner and do not owe any debt. Now, for many types of debts, the assets in your estate will be used to pay off the debts. So this means that your property will go to creditors instead of the people that you designated for it to go to that you're leaving behind. Now, their family members are not going to be liable for your personal debt unless they were jointly accountable for it. But again, for a lot of debts, debtor collectors will come for it as long as it falls within that property or loan. Now, continuation of this. If your belongings are going through an estate proceeding, so probate or administration, then the designated executor is going to have to notify creditors. So those are the creditors that are going to have the ability to take that money away that we talked about. They're going to take the money out of what's been left behind before it gets to the people that you want it to get to. Now, if there's property that's not going through estate proceedings, so life insurance, retirement accounts, payable and death bank accounts, then the creditors are not going to be able to intercept that money. There's obviously exceptions to every rule, but on the whole, those are exempt from those creditor proceedings. Now we've got an 11-step action plan for you to go through. So for the sake of time, I'm going to try and keep it brief. But first and foremost, you are going to want to gather and review all of your necessary documents. So this is going to be everything that we've covered thus far. If you have filled out any paperwork with life planning in mind, you're going to want to keep that in a safe and secure place. And you're going to want to identify dependents in all of your assets. So just get an organized list in order of the things that you own, the accounts that you have, and any dependents that are relying on you day to day. Now, number 3, you're going to want to schedule a time to speak with an attorney or even a financial planning professional, because again, it is complex and you're going to need somebody who can really knows the ropes and the intricacies. So number 4, you're going to title your assets and property in the manner you refer. Number 5, your named beneficiaries for your life insurance, retirement plan, etc., if it's applicable, because not all of them require a beneficiary, but that is the easiest way for the money to go directly to a person instead of having to go and read through your will in order to find out who it's going to. Number 6, decide with an attorney if you even need an advance directive, will, and/or trust. Because depending on your assets, depending on your specific situation, you might not need to do all of the paperwork that we had mentioned throughout this presentation. Now, number 7, discuss Social Security survivor benefits with possible recipients. As was mentioned before, if you're going to be leaving behind benefits, if you're leaving behind money as well, that could affect somebody else's situation and their eligibility for benefits, you're going to want to let them know. Number 8, make funeral arrangements if that's your preference. Again, just saying what your wishes are after you pass away. Number 9, make a list of all of your documents. So like was mentioned before, all of your bank accounts, your investments, etc., including the online ones, and make sure that it is in a safe place because it's going to have your account information, the ways that other people can access it. You want it to be locked up tight in a safe, secure place, but make sure that your will's executor can access that safe place and knows where to find it. Number 10, make sure all necessary documents are in a folder. And once again, reiterating, safe, secure place, and letting your loved ones or your executor, anybody that's going to be in charge of dealing with these documents, let them know where it is and how to get to it. And finally, number 11, reevaluate your estate plan after major life changes. So this is an ongoing step because anytime something is changing in your life that could affect your assets, so deaths, births, illnesses, divorce, reevaluate your plan, who it's going to, who your beneficiaries are. Just make sure that it is always top of mind throughout life changes. So we threw a lot at you today, but we just have a little conclusion for you. End of life planning is really about making sure that you have the peace of mind and know that as you're dealing with life and everything that's coming in these years, that you know what's going to happen to all of your things, all of your assets when you pass away. So after gathering all these necessary documents, you can go about deciding how you want your loved ones to be taken care of and how your assets will be distributed to them, and just really giving yourself the comfort of knowing that there is a plan. It's important to think about the roles that assets and property titles, retirement plans, insurance, everything that we talked about plays in the end of life planning, because it's all part of a bigger picture of what you're leaving behind. And finally, it's important to talk with an attorney or a financial professional about all of this estate planning. You are an incredibly capable individual and you are taking the right steps to educate yourself, but we highly recommend not going it alone. Don't just do it yourself because you don't have to. And this is our contact information because, as was mentioned before, our office does a lot of civil legal work. So you can call our intake line at the number here. You can leave a voicemail containing your information, so your name, the way that we can best contact you, and just a description of what's going on, what your legal problem is. If there's a pressing deadline or something coming up that you really need us to know about, please include that as well. You can also visit our website or send us an email at what's on the slide here. Now, we have an intake procedure here that's usually done over the phone. So generally somebody will leave a voicemail and we will go through them systematically to see if they're eligible for our services. And if not, we'll call back with referrals to places that might be able to help you out with your situation. So during the process of calling back, our staff is going to ask questions about the legal issue, take down demographic information, because again, we are funded by grants and we just really need to make sure that we have crossed all the T's and dotted our I's. So again, if we're not able to assist, we have plenty of referrals so that we can make sure that somebody is assigned to your case appropriately. Thank you so much for your time. Please reach out anytime. We are here in Bed-Stuy, Brooklyn, and we are always happy to hear from you.
So I think what we'll do is just stop sharing so that we can see everyone and answer questions. Hey, everyone.